I will try to briefly present what the AI Act talks about. It's difficult to describe the specific regulations here, but I'd like you to have a rough idea of what to look for there if necessary. A few such sentences by way of introduction. What is AI Act at all? It is a European Union regulation. What consequences does it entail? The consequences are that we apply it in all member states without really needing to introduce national laws. So the AI Act is the same in every country. These rules apply in every country of the European Union. And in general, it is the first comprehensive regulation of the AI area in the world. It was intended to protect against the negative effects of AI while supporting its development. Will it succeed in practice? That's a bit of a different story. However, I will try to outline these regulations. Who does the AI Act concern? I mean, which groups of entities can look for regulations that will apply to them? Here on the slide, you have 6 such groups. My intention is not really to explain how one should understand the provider or the entity applying AI or the distributor under the AI Act. But I wanted you to have a sense and understanding that the AI Act encompasses this whole chain of entities from the developer, that is from the solution provider, all the way to the end user. So if we are an organization considering some automation, then we will be an applying entity. We have to check those regulations that refer to the applying entity and check if it restricts us in any way or if we should approach it differently in any way. If we are a software house building a tool based on AI, then we have to look at these regulations concerning the provider. But if we are only a reseller, we will also be included in some extent by this regulation. Similarly, importers who bring these solutions into Poland from outside the European Union are also covered communities. And one last issue in this context, the impact of this AI Act, contrary to common belief, is much greater than just the European Union, similar to GDPR. But why? Because if we have a solution provider from the United States, contrary to appearances, it will also be subject to these regulations as long as this solution is sold in Europe or targets European users. Therefore, in reality, if a provider from outside the Union did not want to be covered by the AI Act, they would have to conduct their business very specifically so that the solution reaches a limited market. So in practice, the impact is much greater than just the European Union. And here you see a calendar on the slide. This is great, in my opinion, an important issue, trivial, because no one looks at such regulations when analyzing the law, but it is a very important issue. Well, the AI Act comes into force gradually. That means it's not like all the regulations are effective at once, but we have these individual moments when, so to speak, packages of regulations start to take effect. And the first date, that is August 2024. This is the beginning of the AI Act implementation, but just the beginning. What does it mean? It is only the moment when these regulations formally started to be laws and not just a draft of some regulation. And from that day, we could truly have knowledge of what the AI Act says. But there were not yet any real addresses of these provisions. However, on the 2nd of February 2025, just recently, the regulations that govern prohibited practices came into force. Here, there was talk about what we would like not to be subject to automation. And here, in the context of the AI Act, we have regulations on prohibited practices. That is, these are the practices that these models or these AI systems that would be unacceptable within the community. I'll talk a bit about them. It seems to me that this is very important right now because, as you'll see, the upcoming dates are a bit postponed. So let's focus on what is currently in effect and what we understand better. Why do we understand better? Because the European Commission issues various types of studies, which the specific issues explained, these regulations and how they are very general. I mean, if we looked at the regulations and wanted to identify the consequences, right? At first glance, it's very, very difficult. This paper that was released recently on prohibited practices has 135 pages and the regulation has 60, 8 lines. So I will try to show what the document is about and how to understand the individual regulations. In August of the 25th year, we will have obligations concerning general purpose model providers. General purpose models are those models like about the most general formula of the GPT chat type and so on. So it's a bit beyond like the subject of our interest today. I would leave that for now. However, this the 2nd of August 2026 as the date to mark in the calendar for most companies that are implementing these solutions, because that's when the majority of the regulations really take effect. That's the date when these basic applications will be effectively regulated. The 2nd of August 2027, that's the final date. These are very detailed regulations concerning high-risk AI systems from Annex number 1. I will not focus on that now. It concerns such products that are covered with special regulations within the Union. It concerns toys, machines, medicines, and so on. So it is a very detailed matter. And now the AI Act has this risk-based approach. What does that mean? That the intensity of prohibitions or mandates regarding individual AI systems is related to the level of risk they generate. And we have 4 categories of this risk. At the highest level, meaning those most interfering with rights, these are prohibited practices which will be unacceptable. Then we have high-risk systems, and fundamentally the AI Act is about this. That is, most of the AI Act's provisions are about how to behave when we have a high-risk system. Limited risk systems are those systems that do not generate significant threats, but are subject to regulation. An example is chatbots. From the perspective of the AI Act, this is the lowest level of intervention and risk, so to speak. On the other hand, minimal risk systems are those we could call systems based on artificial intelligence, but which are not subject to regulation. These are quite simple solutions. For example, I don't know, some AI-based spam filters that do not significantly interfere with the rights and freedoms of individuals. And moving on to these prohibited practices, there are probably 8 or 9 of these practices. I tried to lay out these regulations on a slide here to make it easier to understand. I'll try to describe some of them. And now prohibited practices are banned concerning all categories, so to speak, of market participants. So if we have a prohibited practice, we are not allowed to introduce it to the market. We are not allowed to distribute it. We are not allowed to use it. To be clear, if we wanted to develop it ourselves, or if we wanted to use an existing solution, and if it falls under prohibited practices, then we cannot use it. And the first such group of these prohibited practices are AI systems that are based on subliminal, manipulative, misleading techniques. If they lead to the distortion of decisions and of objects, subjects of this AI, with the effect of causing serious harm. Well, what are subliminal messages? Well, we know intuitively. It's about all those situations when these AI systems would generate, I don't know, images, sounds that would be identifiable at the level of, let's call it colloquially, the brain, but somewhat beyond our awareness. So if we had such an AI system that subliminally inclined us towards something by distorting our original decision, meaning we could assume we would have made a different one if we hadn't been treated this way, so to speak. And this in turn could lead to harm. Then we already have the complete definition of the first case of practice. Forbidden. Such an example exists if we had such a system in a shopping mall to which would monitor the behavior of people in that mall, identifying, for example, some of their I don't know, susceptibilities, weaknesses, or interests, and using this in a subliminal way to suggest some purchasing decisions, then we would have a solution that would be would be impermissible here. The second case is built a little differently because it's not about the technique itself, but about the recipient. It's about recipients who are characterized by some kind of vulnerability. This vulnerability may concern age or economic situation. Children or elderly people are a perfect example of this. And here is an analogous construction. If we had a solution that would target such audience groups and you, by using AI, it distorted their potential decisions resulting in harm, then again, that would be a prohibited practice. However, one clarification, this harm does not have to be strictly financial harm. It can be harm of a completely different kind. The European Commission provides as an example here an app for children that would monitor the level of a child's engagement. And at the moment when this engagement would drop based on the dopamine loop mechanism, it would give extra points as if increasing engagement in the game and causing a permanent extension of the game. So here, we don't have harm of an economic nature, but we have harm in the form of... Yes, please, I have a question regarding the use of robots from the perspective of elderly people. Let's assume that such artificial intelligence recognized that it is an elderly person and thus used language to explain, for example, a solution to their problem to a potential client. Was there some kind of shaping to a decision that might, for example, work better if I made some purchasing decision, but it would still be using the knowledge that it is an elderly person, and thus the language would be adjusted? That is, I believe, quite the opposite, because if we have a simplified language, but we have no guidance here towards distorting this decision, only really towards the explication of some problem. Quite the contrary, I would consider it a valuable tool. As for older people, the example is different there. The example is this. So if we had an application for older people, which it would be, at least it would be advertised as an application that helps with financial management. Another example concerns the so-called scoring, social scoring. When I saw this regulation, it reminded me of an episode of Black Mirror. There was one once, exactly touching on this issue. Social scoring under the AI Act is aligned with that intuitive understanding. It refers to a situation where this AI system monitors behaviors and characteristics of individuals over time, classifying and evaluating them based on those behaviors, right? If this social scoring would lead to unfavorable or harmful treatment, but in a manner unrelated to the data that was collected or in a disproportionate way, then we would again have an example of a prohibited practice. Let's set aside the classic Black Mirror scenario, such as situations where people are monitored on social media, or, for example, whether they litter on the street and then their taxes would be raised. Well, that's obviously unacceptable. However, what's much more interesting is the issue of a real application closer to home, for example. AI system in credit worthiness analysis. Well, this social scoring, this ban on social scoring does not exclude conducting automated assessments of such credit worthiness, but this examination must relate to real events, meaning those that have a real connection to credit worthiness. Because classic social scoring would say, we look at how this person engages socially, what kind of person they are, or if they are late to school, and then, for example, deny them credit. Well, this is an example of prohibited social scoring, meaning scoring where we have the analysis of behaviors and the final decision, which is unrelated to the behaviors we analyzed. Yeah, one more question, because everything you're talking about is such an intentional deception, intentional, which is not social. And what if AI is trained in such a way that it's unintentionally misleads or unintentionally, let's say, I know such AI that when it somehow detects emotions, however, when I wear glasses, it's not as good. And then, for example, it tells me that I'm sad when I'm not sad, and I might be unhappy about it. But isn't it then in that sense, is it legal when non-intervention is trained? That means I might get back to that question in a moment, because we will talk basically maybe now, not now, in a moment, because you are actually asking about emotion recognition or so-called sentiment. This is a completely different kind of prohibited practice. I will get to that in a moment, and we will return to the question. But before we get to that, we have biometric categorization, which would lead to the identification of these specific parameters visible on the slide, such as race, political views, union membership, and so on. Well, this is obviously an extreme case. Yes, because there's a question in the back. I have a question about this point. What about, for example, scientific research in which, let's say, different ethnic groups are studied? I don't know if it's allowed. Behaviors of specific organisms. And what I mean is that, for instance, different ethnic groups may react differently to various substances. Can they react differently in some way? Would metaphors, would the use of AI in such a case be prohibited? That is, but I indirectly understand that this system is not meant for categorization, meaning not for extracting people of specific races from a group, but we have input data where that race is already present, and then we are to perform a susceptibility analysis, though I don't fully understand. I understand that it is allowed, but if it will be, I don't know, won't be a bonus element or such segregation using AI based on these criteria. However, it is different from conducting comparative analysis in the scope of some study results. Let's start with the fact that biometric categorization and in general, biometric categorization under the IAI Act is only understood in this way if it is not part of another service. A simple example is if I were recognized my silhouette from the perspective of even those characteristic features for various races in order to show me how I look in a particular sweater. That's not the issue. That's not the issue because it is part of a service. It's like an intermediary operation that serves something other than my categorization based on race or other such characteristics. Okay, moving on, I won't dwell on this much. However, profiling, meaning building such profiles of people in terms of the risk of committing crimes is prohibited. So we cannot, similar to social scoring, we cannot monitor from a state perspective because that's mainly what it's about. Individuals and to construct their profiles a priori on the basis that citizen X exhibits a potential threat at level Y while citizen X at level Z, right? So that's unacceptable. Or this is another, yes, exactly, because it is an assessment of the risk of committing. It is an assessment of the risk of committing, exactly. And drawing conclusions about a person's emotions, that is the so-called sentiment analysis. And this is a super interesting case because among all those cases, it is, so to speak, closest to business realities. Why? Because it is prohibited in the workplace. In connection with which for various HR solutions, this is of crucial importance. I just wanted to explain this specific point a little more broadly. Well, firstly, through emotions, one must have awareness. We do not understand such traits of physical symptoms. So, for example, fatigue is not an emotion. If in a transportation company we wanted to use AI to monitor drivers' fatigue, that is okay. That is not the driver's emotions. Similarly, if we wanted to monitor any physical signs, movements, a wave of the hand, or even a smile itself, a smile is not considered an emotion under these regulations. Emotions are joy, sadness, which are those very specifically understood emotions. And now one more thing. This regulation talks about studying emotions based on biometric data. So if we were identifying emotions in the workplace based on, for example, employees' texts, again, we fall out of this regulation. We would have to look at data biometric. And I'll add that here, the European Union is keeping up with the times in the sense that the workplace should be understood very broadly. And employees also include B2B collaborators, also both remote workers and those working exclusively on some platforms. So a very broad definition. What is an interesting case here? What cannot be done? And at the same time, what can be done? Considering all these elements I've mentioned, we cannot monitor call center employees in terms of listening in or monitoring their behavior regarding assessment, whether they are, for instance, nervous, as that would involve drawing conclusions about emotions in the workplace based on these biometric data. But you can monitor the caller in the same way to give some advice to the agent on how they should act. Or, for example, if the person, this caller, is already showing some symptoms of nervousness that we wouldn't detect in the simplest way, empirically, but rather at the level of analysis. Through AI, I have two questions, if I may. The first question is because everything looks like and everything indicates that most companies will use AI in a model where they will purchase a solution as a service, meaning something ready-made, and then use it for their own purposes. What obligations does a company that buys this tool have then? Do we need to somehow verify that the solution we purchase complies with the AI Act? Exactly, that's what I was talking about with the first slide. That unfortunately, yes, we cannot approach it in such a way that if there is a solution, it means it can be used. It doesn't work like that. Classifying, because really a lot of responsibility is then placed on the company, right? Because I understand that the way a product uses AI is, let's call it a secret of the company, a business secret, which they do not necessarily want to share. So imposing on me as a buyer the duty to verify how they are using AI and what is, as it were, inside their product. This is something impossible to achieve. It is indeed a problem. Of course, we will see how it looks in practice. I also remember when GDPR was being implemented, questions arose at every step, and basically there was more chaos in this context than a real sense that we know where we are heading. However, it seems to me that identifying prohibited practices should not cause major problems here. Things are quite clear, quite precisely described. It seems to me that someone knowledgeable, when tasked, can do this very easily. I mean, very easily. It's relatively simple to assess. It's worse with high-risk systems, because there the assessment of whether something is high risk or limited is problematic, and the obligations are completely different. I'll also address this in a moment, but there's still some question. I would like to address that colleague's question from a moment ago, because YY is not about certifying the tool, because it would be like certifying a hammer, right? A hammer can be used for various purposes. So Yim, it's not even about there being no certification for AI products. However, the AI Act actually approaches from this point of view, what will you use it for? How will you configure this tool? I mean, only if the tool is ready, and this tool in a ready manner does the task of monitoring those call center employees to identify their emotions. Then we have a per se prohibited practice, and at the same time, it is a tool that we bought off the shelf in a store. I understand that this is the case, but the AI Act is indifferent to it in the sense that you are the applying entity. Well, you have to verify if this is not a prohibited practice. So probably in practice, does this mean that we will be sending a questionnaire to the supplier? Do you use AI in accordance with the AI Act? And this will mean that we have exercised due diligence. I would call it a facade implementation of the yacht in the organization. Please declare whether it is compliant and whether it does not constitute a prohibited practice. Yes. Well, let's go. Yes. Okay, one more long question, if I may. Generally, you can feel a breeze of deregulation coming from the West. We see this in the United States, and we see some movements starting in Poland. I don't know, do you perhaps have any signals and so on? that this AI Act at the European Union level may be slightly changed. Honestly, I haven't heard such voices, but in my opinion, the more important issue is not whether it will be changed, but how intensively it will be developed and refined. Pay attention, because it's like this: a regulation is a regulation, but as I said, it depends on how much the European Commission will deal with guidelines, how much the European Commission will tighten these regulations, and how much they will loosen them. That seems to be the key, because we don't have much doubt that these prohibited practices, well, they shouldn't take place in the sense that they aren't really controversial things. A bigger problem, business-wise, arises with these high-risk practices, where there is a lot of documentation obligations related to risk analysis that a small organization simply cannot handle, right? Now, even GDPR is relatively simple, because everyone knows there must be data security, there are some reputable providers, so we can somehow manage that, right? But when we create an AI solution, we have to create all the documentation around it. And for really small organizations, it will be problematic. Therefore, I believe that small organizations tackling these high-risk systems will face entry barriers. And this certainly doesn't positively affect the competitiveness of this market. Okay, I will skip 2 more cases. They are described on the slide. These are really matters far removed from, so to speak, business. Here we have the prosecution of crimes based on remote biometric identification and the creation of databases from recognized faces. I leave these 2 cases because we will not finish this in any reasonable time frame. Okay, I mentioned high-risk systems. In a nutshell, we have 2 annexes to the AI Act, which tell us about the areas that will potentially be high-risk systems. That is biometrics, critical infrastructure, education, training, and so on and so forth. Among other things regarding employment here, meaning AI solutions in employment are, in theory, by default, those high-risk ones. It's quite logical, but we have an exception here. Namely, an AI system will not be considered high risk if it performs a narrowly defined procedural task or is used to improve the outcome of previously completed work by a human. So, and here it emerges from the AI Act in many places that as long as we have a pilot with this solution, well, it is treated differently than a system that autonomously performs these operations. And this, which I mentioned quite briefly, it concerns obligations with high-risk systems. These are example obligations for the provider. And look, we have a risk management system, proper data management, meaning the appropriate quality of training, validation, and test data, preparation and maintenance of suitable technical documentation, ongoing event recording, ensuring transparency and informing. This involves creating instructions and instructions for interpreting results. Such a solution must have human oversight over the system, and so on and so on. So we have a series of requirements. Well, these are not things we can quickly make up here. It's an approach somewhat like with GDPR in terms of accountability, that simply when building a solution, all these elements are already foreseen at the design stage of the solution. And the last topic I wanted to address, so we have limited risk systems, which I mentioned, those at the lowest rung of the ladder, regulated by the AI Act. And there we have 4 obligations I wanted to mention, 2 for providers and 2 for users. As for suppliers, that is when we have AI systems intended for direct interaction with individuals, like our chatbots, we have an obligation in 1.5 years to inform the individual that they are interacting with an unreal person. But here is a caveat, unless it is obvious from the point of view of that individual. So if we have this case, hi, I am there, right? Various examples of names have been given here, and I am there, a bot, or whatever we might call it, or if I'm digital customer support, then we don't have to provide any detailed, extensive information. The second issue, this system that generates sounds, video images, or texts must be marked in a machine recognizable way. indicating that these materials were automatically generated by AI, and regarding it doesn't display, yes. However, as for the users, we have two situations, and it's about deepfake. So deepfakes must be marked in the same way, unless they are part of some satirical or artistic material. Clear again that they're not real material, then there's no need for specific labeling. It's enough just there. Finally mention that it was created using such solutions. And the last element concerns informing the press when we have a case of informing the public about matters of public interest. We need to indicate if such material was generated by AI. I don't know if you've noticed, this feature appeared recently. My colleague also pointed it out to me. On it, there is a feature to generate a shortened version of an article. When we click on it, a message automatically pops up saying that this article was shortened automatically using AI technology. And that is exactly, one could say, the formula for implementing this solution, meaning the entity using it, which uses this solution, automating messages of some kind of significance, social significance. If these are materials other than those informing the public, then this obligation does not exist. Theoretically, we still have the last slide, but just in a few words. Well, the AI Act does not override all other regulations. So if we are compliant at the AI Act level, meaning we have a solution that is a limited risk solution, we are regulatory okay here. It may further turn out that the advertising we use is somehow unfair, or it may further turn out that the processing of personal data is not in compliance with personal data regulations. So the AI Act regulates artificial intelligence, but this only per se artificial intelligence. Other regulations still apply and must still be considered when designing or implementing such solutions. So I have a question. Yes, please. There are enthusiasts, but there are also severe critics. And now from the point, there are no critics because they generally believe. In Europe, they even refer to it harshly as a museum in terms of technological development. So we will be much weaker in terms of technology. And now if you were my lawyer, knowing how much deeper, for you to be deeper than us, right? From the perspective, what does it involve? If I had a great idea and a lot of money, I mean, would you advise me to invest outside of Europe or to develop within it? But it's much more complex. I'm not an expert at all. You could ask Maciek about doing business in the States, because I think it's hard to look through such a narrow prism. I mean, of course, it is a disadvantage for this location, but in general, Europe or worldwide, is even Poland the worst or bad place for developing business? It kind of depends. Well, different investment potential, different conditions. The AI Act is a downside, but the overall assessment should be made in a broader context for sure. I think we need to pay attention to what Paweł said at the beginning, that, hey, even if, I don't know, Zawi is a company in the States and provides services here, it also applies to us. So any company from the States wanting to sell to Europe. So the question is whether it won't simply be that. In the United States or other countries where there is no AI Act, will there be solutions available that we won't be able to adopt here? And I think that's the biggest challenge, that technologies will emerge that these companies simply won't be able to introduce here. So that's what it's about. It's one of those arguments for technological limitation, right? That investors from outside the union won't really want to do business here either. Well, yes, but a solution developed outside the union will have limited applicability because it will only address markets that in no way interact with EU citizens. So we would have to operate only within the United States or only outside the union in some selected locations. It's hard for me to imagine someone building such a solution unless it was to solve a specific local problem. But that also needs to be forgiven because it's not like there is any kind of cushion in the States. I mean, I worked at an American company where we were doing an AI solution for our hardware in a team where we simply scanned coil springs, so that to make it sorbitize coil springs, we had to work very, very before the lawyers. Can we do this with the solution? and it's not discrimination. Because the lack of another question, whether it was intentional or unintentional, nobody was interested in whether it was intentional. Here is the end result. As a result, so to speak, the HR head told us very clearly, so to speak, that year the lawyer is supposed to say whether the evidence is sufficient, strong enough to potentially defend the company in court, so to speak, that there was no discrimination. So that also means, if I may say, that Europe regulates. On the other hand, you can't just imagine the law as anything goes and everyone goes on like that. That is completely half jokingly, half seriously. There are different amounts of compensations in the United States when it comes to the overall business balance. But there is also, at the company level, yes, a company knows that if it gets sued for something discriminatory, it could be less formalized. The second reflection is that I work in a very regulated sector, namely in a pharmaceutical company. And there, the FDA, which is to say the American Federal Drug Administration, also has thousands of restrictions regarding the use of AI and so on. So let's not imagine that these are, so to speak, two extremes, right? No, basically it varies. With we have several clients who there is a special Californian law that says you must inform clients that their conversation will be recorded, and we have situations where some of our Windows widgets. At the very beginning, clients have a much longer message about the conversation being recorded with reference to the terms of services and so on, because they are afraid that any lawyer can sue them. And there was a moment for half a year where a lot of clients who already had live chatbots were receiving random lawsuits from some people from some strange state, some simply Kowalskis, that they were not informed about this. Sometimes they won those cases, so it's not really like that because here it's somehow centrally regulated, and there each state is different, each looks different, and indeed work is being done on it. This is in turn a culture of litigation, right? And the court decides. So it's a somewhat different ecosystem, so to speak. It is, but I think we'll get through it. And going back to whether we will be a relic, it's hard to assess now. I think time will tell how all this will be implemented. There are many companies in the United States that sell to Europe and are still not compliant with GDPR. And no one has done anything to them to this day. That's the truth. Paweł will answer. Okay, listen, I think we will slowly wrap this up. There is one more question. Okay, the last question, and we're on because we are way over time. Any controversial regulations, and could I know what very controversial regulations there are concerning Qatar? Controversial regulations? Because there are regulations here that simply already concern the prohibition, the highest level, native. It's hard for me to recall that statement, what I really meant when I spoke. However, I might have been referring more to the fact that with these high-risk systems, there are a number of obligations that I showed on the slide concerning documentation, monitoring, recording incidents, and so on. I think that's more what I meant. It's hard for me at this moment. Recall this statement. Listen, Paweł will be here. I see that Paweł should organize some longer 1 hour, 2 hour webinar on all this here. So thanks a lot and goodbye.